I'm Kyla at Acumen Law, and today I'm answering your frequently asked questions about immediate roadside prohibitions. In a 90-day immediate roadside prohibition for refusing to provide a sample, you can argue that the demand for you to provide a sample of your breath was not valid. Demands for people to provide breath samples at the roadside must meet certain legal requirements, and there are different types of demands depending on what the officer believes at the time. In those circumstances, it's important to have the assistance of a lawyer to understand the legal requirements of each demand and whether they're met. If you attempt to provide a sample, you can argue that you did not intentionally refuse to provide a sample. You can also argue that you had a reasonable excuse for refusing or failing to be able to provide a suitable sample, either by way of medical excuse, by way of a violation of your charter-protected rights, or by way of some other circumstance that transpired at the roadside. In an immediate roadside prohibition for providing a warn or a fail, the defenses depend upon the collection of the sample, whether the result was reliable, such as not being impacted by residual mouth alcohol, or falsely elevated by having an elevated mouth temperature, or other issues like that, whether the blood alcohol concentration exceeded the legal limit, which will depend on how much you drank, over what time period, what you weigh, and what drinks specifically that you had. In addition, you can also argue that your right to a second test was breached. Officers are required, if you provide a sample that registers a warn or a fail, to advise you of your right to take a second test. The second test is required to be conducted on a different approved screening device, and if you request a second test and the officer does not provide you with an opportunity to take one, then that may be a defense as well. Information related to the devices and the information the officer conveyed surrounding the second test is often included in the police report. Finally, in either circumstance, you can argue that you weren't a driver. This means that you have to be driving or in carrying control of a vehicle on a highway or industrial road at a relevant time in order for the prohibition to be applicable. This is a very complex area because care and control doesn't just mean driving the vehicle. It also doesn't just mean that you're on a roadway. For example, if you're in a parking lot, you may or may not be on a highway or industrial road. And in circumstances where there was a long disconnect between driving and actually being issued the IRP, it will depend on the type of evidence that's available to connect you and the driving to the actual issuance of the IRP. All of these things are issues that a lawyer can help you to identify and help you to argue in your case.